Hello, everyone. My name is David Schwartz, and I'm the practice group leader of Thompson Hine International Trade Group, and I'll be serving as your moderator for today's program, our first in a series of 4 weekly programs on the USMCA. As everyone knows, the USMCA will be replacing the NAFTA on July 1st. Today, we'll be focusing on the USMCA labor and environmental protections. Before we begin, I have a few housekeeping items for you to keep in mind. Today's program is being recorded, and we will send a link to all participants within 48 hours of today's presentation. If you have any questions during the webinar, please use the question box located in the control panel on the right side of your screen to submit questions. We'll answer as many questions as we can at the end of the webinar. In the handout panel, you can download a copy of the PowerPoint slides and the biographies of today's speakers. Again, thank you for your interest. We're glad you could join us. And if you have any questions as we go along, please use the question box on the right-hand side. At this time, I'm delighted to introduce our panelists. Joining me today are Juan Carlos de la Vega, labor employment lawyer at Santa Marina Esteta. He's been practicing for over 30 years, and he's currently the managing partner of his law firm, which is based in Mexico City. 2 colleagues of mine from Thompson Hine will be participating. Scott Young, who's a partner in the Labor and Employment Practice Group, and Joel Eagle, a partner in Thompson Hine's Environmental Practice Group. At this time, I'm going to allow Juan Carlos to get us started with our presentation focusing on the labor protections under the USMCA. Juan Carlos.
Thank you very much, David. Hope everybody is listening me well. The labor chapter in the USMCA is perhaps one of the most important parts, at least for Mexico, considering the repercussions it will have, and it is already having in my country. We must remember that with one of the intentions when NAFTA was put into place was to build not only a common market of consumers, so not only eliminate the trade barriers, but creating this North American market that of consumers didn't happen. Mexico labor standards remain quite low compared to those in the United States and in Canada. So there was lots of international pressure on Mexico because they thought that we were dumping by simply offering investors low, cheap labor to attract investments. So because of that pressure, United States unions do their work and influence this new USMCA so that with the purpose of bringing the level of salaries and work conditions in Mexico to a similar point as that of our North American neighbors to the extent possible. So we compete under a similar basis and create also this common market for consumers. So one of the things that there's basically 3 or 4 main principles as relates to labor that applies to the 3 countries. One is the freedom of association and the right of collective bargaining. So we have as countries the duty to provide for guarantees on the respect of these 2 principles. Elimination of compulsory labor and child labor, it is another important commitment, and building acceptable conditions of work with respect to minimum wages, hours of work, and occupational safety and health. So those are the 3 main labor principles which inspire this labor piece of the USMCA, and they apply to the 3 countries. And in order for that to be applied, the countries are required to produce legislation so that there is sufficient enforcement of those principles, including constant and objective labor inspections, and the access to impartial and independent tribunals for the resolution of labor disputes, and also effective enforcement of labor rights and remedies. And as you may probably have heard, when this USMCA was negotiated, our North American neighbors did not believe that Mexicans were going to commit and to enforce just because of these principles, and that's why this new rapid response labor mechanism about which Scott Young will speak about was put into place. So in order to, which is a very clever system, by the way, to make sure that Mexico is in compliance. The other piece that I'd like just to go through, if I have a few minutes more, is how this new treaty impacts Mexico union environment, because it's going to change totally the rules as to how we were used to handle things. Again, because of historic reasons, political reasons, Mexico rarely did respect the principle of freedom of association and the right of collective bargaining. There are a few good cases that we do, but I think the most constant is that we did not. And of course, that affected the labor conditions of the workers in my country. That's why, based on this, there's an Annex 23A, which applies only to Mexico, and it speaks about Mexico committing to guarantee that employees shall organize, form, and join the union of their choice, and establish provisions to respect that which we partially comply with, prohibit employer domination of or interference in union activity. So it's now going to be prohibited for employers to get involved in the life of unions, and employers used to control a significant part of the life of the unions. So we cannot discriminate against those employees who may wish to be part of another labor organization. We're supposed to respect now the democracy principles in union elections, which we did not till now. The election of union leaders should be also made by means of a secret vote. And it is exactly that, the secret vote to which people is now entitled to, that will totally change the circumstances. And it is a direct and secret vote. There needs to be a dispute resolution process for when there are union elections. They usually took many years to get resolved. So the procedural rules have changed now to make that a short process. There is the introduction of a new principle that we were not used to. It's when you do collective bargaining, and there is an agreement reached between the company and the union, whatever the product of that negotiation will have to go down to the people, to the employees themselves, who they, through a secret ballot, will decide whether they support or they do not support the result of that negotiation. And that brings a totally different world, because this variable we were not used to. Simply, we get an agreement with the union, we sign it, and that's it. We apply it or communicate it to the people, and we're all happy. Now we need to go back and consult with the people, and they need to vote secretly to confirm that. And if they don't confirm, you're supposed to go back to negotiate, or the union has the right to strike. So we should be alerted on strikes. There will be definitely a lot more strikes than we were used to, and we need to be prepared for that. So that's, in a nutshell, those are my big comments about the labor piece on the USMCA. Thank you very much, David.
Thank you, Juan Carlos. And now my colleague, Scott Young, will address the USMCA's rapid response labor mechanism and how the USMCA labor provisions affect the rules of origin.
Thank you, David. Yes, so as Juan mentioned, there are a number of provisions within the USMCA that sets standards in terms of how all of the countries, but certainly the US, Mexico, and Canada are certain general rules with respect to employees, and one of them, as Juan mentioned, was the collective bargaining and aspect, anti-discrimination laws, et cetera. And then from the rapid response labor mechanism, certainly we can have an agreement, but then the issue is, well, how do we enforce it? How do the parties to the agreement enforce it? And that's where the rapid response labor mechanism comes in. And from that vantage point, and there's basically one rapid response labor mechanism that's set up specifically between Mexico and Canada, and another one with respect to the United States and Mexico. And I'm going to talk about the one as relating to the United States and Mexico. And from that one, it provides that there's going to be basically a panel that's going to be comprised of 5 members, that Mexico or each of the parties will establish three lists for the rapid response labor panelists. One will be chosen, or rather one will be chosen by the United States, one will be chosen by Mexico for 2 of the lists, and then by consensus 3 individuals to a joint list. The individuals in the joint list shall be non-nationals of either Mexico or the United States. The additional provisions within it is there's an agreement in terms of a minimum of 4 years or until the parties constitute new lists. As well, there's a requirement that each of the labor panelists have an expertise and experience in labor law and practice. That they be selected on the basis of objectivity, reliability, and sound judgment, that they be indicated to be independent from any party, and that there's also a sort of a code of conduct that is going to be established in terms of ethical behavior by the commission, and they must also agree to comply with that as well. And then in terms of the next slide, in terms of what can the rapid response labor panel do? Well, basically the panel exists where if a party to the agreement, meaning the United States or Mexico, believes that there is a business that from a labor aspect of it may be violating the rules, perhaps the collective bargaining aspects, some of the safety rules that are required, some of the rules against forced labor. Certainly, there are also general protections in place in Chapter 23 with respect to anti-discrimination provisions that the panel will get together and they will basically conduct a hearing, allow for the parties to submit briefs, hear evidence, and then they'll make determinations based upon whether or not there is evidence to support the complaint and that the actions of one of the parties is inconsistent with the terms of the agreement, whether or not it's a material impairment or a material infraction, any other determination that may be requested, and then a remedy for relief as well as being requested by the parties. And in terms of what the agreement provides, the remedies provide that there could be a suspension of preferential tariff treatment as relating to that particular business and its goods as being manufactured and sold. There could be an imposition of penalties. So it's very significant stuff in terms of what this labor mechanism permits. and the idea behind it, and again that you have basically a panel of 5 judges, where in theory 2 could be from Mexican nationals, 2 from United States nationals, and a third one on the panel, or the 5th one on the panel, would be of neither U.S. or Mexican origin, or national. And so that is sort of how the rapid response labor mechanism panel and what its authority is. There's also significant as part of the USMCA are rules of origin as well that are set into place that are there to help the US, Mexico, and Canada in terms of ensuring from a auto content that immediately the requirement is, and once the agreement goes into effect, that 62.5% of certain aspects of auto content be made in North America, rolling up to 2025, where the requirement is if auto content is to be sold in these countries, that 75% of it has to be originated in the US, Mexico, and Canada. So yes, we have, as Juan was talking about, sort of added rules that will somewhat level the playing field, or sort of make the rules of labor sort of equal with respect to how Canada and the US and Mexico sort of agree in terms of managing their workforces. But also there is some specific added benefits as well that will be good for all 3 of the countries that are part of this agreement, such that it will, certainly from the auto content and that is not just the vehicles, but also the parts that go into the vehicles, that by 2025, that 75% will be made in North America. And that the hope is, and the idea is that will incentivize billions of dollars annually in the region. It will help preserve and reshore vehicle and parts production in the United States, Mexico, and Canada. And certainly with respect to North America, there's always the talk about making cars and vehicles in Asia, and so this should help bring manufacturing further back to North America. It will also transform the supply chains to use more North American content, which should be key for all 3 countries in terms of future automobile production and high-paying jobs. And as far as the other aspect that I'll briefly cover is the rules of origin and the labor value content. And from this aspect, and Juan did talk about this somewhat in his presentation, but there are specifically with respect to the auto content, that by 2023, and it's going to graduate. So immediately it's 30% upon the effective date of the agreement, and then gradually goes up to 40% or more by 2023. That percentage of the auto content be made by workers earning at least $16 per hour. And if everyone is playing on this same playing field, that should support better jobs for North American producers and workers. It will ensure that the US, Mexico, and Canada producers and workers are able to compete on an even playing field and incentivize new vehicle and parts investments, and also encourage more investment by auto companies in research and development in the region. And again, the other sort of tying it into the regional content value aspect of the rule, that's going to require by 2025, 75% of the auto parts to be made in North America, and such they can't be made in China or other parts of the world. This should be a win-win for all 3 countries that are involved in this agreement. Thank you, David.
Thank you, Scott, and thank you, Juan Carlos. Thanks to both of you for covering the portion of our discussion regarding the USMCA labor provisions. Now we're going to pivot and discuss the USMCA environmental regulations with my colleague, Joel Eagle.
Thanks, David, and thanks, Scott and Juan Carlos. I'll start by saying that I'm very passionate about environmental law and protection, and this environmental chapter of the USMCA, Chapter 24, and the side agreement, which is known as the Environmental Cooperation Agreement, are particularly fascinating to me. So I'm looking forward to giving you a quick overview. I know our time is limited. I wish I had hours to talk to you because there's a lot to unpack. The agreement, the chapter and the agreement are over 42 pages combined, but I'll just give you some of the key articles and my observations on them. So at a high level, I see the USMCA and cooperation agreement on the environment as representing a great deal of potential for future environmental cooperation among the three countries. The key, as is often the case, will be how the agreements are executed. And I say that in particular because I see many more general statements on environmental cooperation in the chapter and the side agreement than I see very specific binding requirements. For example, in Article 24.3, which is called Levels of Protection, it has statements that say things like each party has the sovereign right to establish its own level of domestic environmental protection and the right to modify this as it sees fit. And it also says that it calls on the parties to strive to ensure that its laws provide for, quote, high levels of environmental protection. So it's very positive language. The question will be how the specific provisions are implemented. I'll call your attention to a couple of key aspects. One being in the Environmental Cooperation Agreement, which is the side agreement to Chapter 24. It retains the Commission for Environmental Cooperation. It's played an important role in the previous framework under NAFTA, but it's been criticized over the years for not being terribly outcome-oriented. So some folks have called on a more specific and important role for the CEC. So we'll see if that role changes going forward. Another important element of the environmental chapter that may strengthen environmental protection among the parties is the inclusion of a list of 7 multilateral environmental agreements, commonly referred to as MEAs. The list includes the Montreal Protocol, the Convention on International Trade in Endangered Species of Wild Fauna and Flora, and the UN Law of the Sea. So the Chapter 24 says that in the event of a conflict between the USMCA provisions and a particular multilateral environmental agreement, the MEA will prevail. And the parties are also required to implement their own obligations under each of these 7 MEAs. And there's also an express provision that allows for the addition of future MEAs should they be implemented. As I'll explain more in a couple of slides, however, the USMCA does not reference the United Nations Framework Convention on Climate Change and the Paris Agreement, which is an important omission. One other thing I'd like to call your attention to is the broad definition in Article 24.4 which is titled the enforcement of environmental laws regarding affecting trade or investment. And this provision says that no party shall fail to effectively enforce its environmental laws through a sustained or recurring course of action or inaction in a manner affecting trade or investment between the parties. So there's a lot to unpack there, and the language is quite broad, but helpfully there is a footnote to this section that clarifies what a course of action or inaction is in a manner that affects trade or investment between the parties. And it essentially says that if that course of action involves a person or industry that produces a good or supplies a service traded between the parties, or has an investment in the territory of the party that has failed to comply with this obligation, or a party or industry that produces a good or supplies a service that competes in the territory of a party with a good or a service of another party. because this of course hasn't been implemented yet, it's not clear how it will be construed, but it certainly is broad language, and I see it as the footnote in particular is an important clarification that may help the parties and may actually lead to greater environmental enforcement of the chapter as a whole. Next slide, please. So I'll go through a couple of the key articles. There are, as I said, it's a very long chapter, and there are many substantive provisions, and there are several important procedural provisions. So I'm just going to highlight a few of them here. On the substantive side, the USMCA provides for new obligations regarding the combating of marine litter. And this is Article 24.12. And the agreement requires the parties to take action to prevent and reduce marine litter by doing several things, including addressing land and sea-based pollution, promoting waste management infrastructure, and advancing efforts related to abandoned, lost, and discarded fishing gear. This does appear to be an important step forward as compared to the previous agreements. Another substantive provision that has received a lot of positive press and attention is the fishing subsidies and several of the protection of fish provisions. Article 24.20 in particular is the fishing subsidies provision. In it, it prohibits certain fishing subsidies in two categories. One are subsidies to vessel or operators, and the other are subsidies that negatively affect fish stock. I call your attention to this provision in particular because constraining fish subsidies has been a challenge on the world stage at the World Trade Organization for almost 2 decades. So the addition of these prohibitions really is a significant positive step for all 3 countries. The test, again, will be the implementation of this prohibition and in the tracking of whether there's actually a decline in subsidies over the coming years. Turning to the procedural side, Article 24.7 introduces a requirement to conduct an environmental impact assessment for a central government project that may have an effect on the environment. So under this, parties are required to undertake these assessments of any proposed project that may cause a significant impact. Although this language appears to be new to trade agreements, existing laws in countries, including the United States, do have a similar requirement. In the United States, it would be the National Environmental Policy Act, or NEPA. Another key element of the USMCA in Chapter 24 is the continuation of the citizen submission process. This is Article 24.27, and it's called Submission of Enforcement Matters. What I observe here is that this article contains some interesting new language that might constrain the citizen submission process. For example, it says that citizens' claims are not to be confused with, quote, harassing industry actions. It also says that, quote unquote, private remedies are to be considered before a citizen claim may be examined. Now, private remedies, the term private remedies isn't defined in Chapter 24, but just observing what it sounds like, it's saying that you may have to exhaust local remedies like tort and civil actions before a citizen can move on to trigger this provision. It also says that citizens' claims are not to be based only on mass media reports, suggesting that more information, evidence would be required before or in order to move forward with submission. I do expect that we're going to see environmental groups in particular seeking to enforce environmental protections under Chapter 24. But this various qualifying language that I just talked about could slow down or prevent citizen enforcement in certain circumstances. Next slide, please. So as you've seen, the USMCA does address pollution and conservation issues in many of the articles, in many media, air, water pollution, things like that. But there is a glaring missing piece, and that's the failure to reference the UN Framework Convention on Climate Change or the Paris Treaty. Even more general than that, there's no reference at all to carbon emissions or any clauses in Chapter 24 or the cooperation agreement to address climate change. The USMCA mentions the word carbon only a couple of times. It refers to the phrase carbon storage in one section regarding sustainable forest management, where it recognizes the important role that forests play in carbon storage. And then it uses the term clean technology in a non-binding section, recognizing the importance of investment in environmental goods and services, including clean technologies. But clearly that those two minor references to carbon are not what many had hoped it would, the agreement would contain. And I compare this, for example, to the recently passed European Union Mercosur trade pact, which does specifically promote domestic and international carbon markets, and also energy efficient, low emission technology and renewable energy. So there's a stark difference between the USMCA and the European agreement. And of course, it comes as no surprise to you all that environmental groups did strongly push for express provisions in the USMCA to address climate change as it was drafted and negotiated. And they were very vocal in opposition to the final language that didn't address climate change, as non-governmental organizations for environmental issues found this to be a critical global issue. So I would say overall, there are compelling articles for environmental cooperation and protection in the USMCA and the cooperation agreement. But until it begins to be implemented, it's hard to say how it's going to stack up against prior environmental agreements among the parties. So thank you very much for your time.
And thank you, Joel. We're now at the formal end of our presentation. We'll move into the question and answer session with what time we have remaining in today's program. We'll address as many of the questions that you've provided us in the time remaining. Any unanswered questions we'll follow up by email with you. If any questions occur to you well after the webinar, please get in touch with your current Thompson Hine contact. And if you don't have one, reach out to me, Joel, or Scott, or Juan Carlos if you have a question regarding the Mexican aspects of the USMCA. To get started, I'm reviewing the questions now. We have a question for Joel on the environmental protections. What do you see as the most significant improvement and the most significant missed opportunity in the environmental provisions of the USMCA Environmental Cooperation Agreement?
Well, I think one of the biggest improvements is the fishing subsidies section. You know, that had been an issue of contention for many years. There are, of course, a lot of waters at issue among the three countries, and this issue of fishing subsidies has kind of been a thorn in the side on the world stage for a long time. So the fact that the parties were able to come to an agreement to reduce and prohibit these fishing subsidies, I think is a very important step. I didn't see a tracking mechanism in the Chapter 24. So again, the question will be, over time, have these prohibitions on subsidies come into effect, and at what rate? And of course, the biggest issue, as I concluded my remarks, relates to climate change. Climate change. It's hard to talk about climate change and not have this become a political debate. Climate change is, of course, a scientific issue, but at least in the United States, it has become a very political issue, with the U.S. Taking itself out of the Paris Treaty. That occurred about a year or two ago, and actually takes effect, I believe, either the day in November, the day of the presidential election, or the day following. So this was for environmental groups and those who feel strongly about global climate change. This was a disappointment, a great disappointment, to not have this language in here. And so, if there are opportunities, like I mentioned, there's some references to carbon, but not very much. So it'll be interesting to see how the next couple of years go, especially if a different administration in the United States comes in and has a different view about climate change as to what this might do for the USMCA.
Thank you, Joel. This question is for Juan Carlos. It has to do with collective bargaining in Mexico. One of our participants today is wondering what companies and counsel are doing to educate the employees at their local facilities about the new rules. Are people planning any training, pushing out notices of any kind? And who are you focusing on educating, management or all of the employees? Juan Carlos, did you hear the question?
Yes, I did. Thank you, David. So the way this works is, first, we have to train management, Mexican management or US management, in case they are or have responsibilities in Mexico. It is important to learn the new rules of the game in order to be able to play the game, all right? So based upon that, once management knows that, businesses ought to define a strategy as to what they need to do based upon the existing union relationship you have in the country, and to define whether that shall continue or rather have a significant change. And now that you have mapped that, then you can perhaps define to train your individual employees or the overall labor force. Now, keep in mind that this is not a simple regulatory change. If you have facilities in Mexico, I'm sure you have some sort of a union relationship. So it is a total change in how we do collective bargaining, in how we handle union relationships. And that's important to keep in mind. So you have to get yourself prepared, because the threats come from different angles. They could come from an audit practiced by Mexican authorities, could come by some disclosure being made at the hotmail line that the United States government opened for even for individual employees, Mexican employees, to say, hey, in my facility, next part of Mexico, there is a violation of fundamental labor rights. And that, as simple as that, could trigger this rapid response labor mechanism. So the threats are really everywhere around. If you are responsible of managing labor relationships in Mexico, if you use protective collective bargaining agreements, and you know what that is, they are now totally prohibited, and you should start thinking about how to change them or what kind of a strategy you should define. Thank you.
Thank you, Juan Carlos. This question is for Scott. From a U.S. labor rights perspective, why is the USMCA important?
Thank you, David. I think probably the key part for this agreement is it sets a general framework that provides a sort of overall construct of a level playing field, and sort of akin to some of the things that Joel was talking about. You know, that from the Chapter 23, which is a labor perspective of the USMCA, I mean, there's a provision in it that says that each party shall implement policies that it considers appropriate to protect workers against employment discrimination on the basis of sex, including harassment, pregnancy, orientation, gender identity, caregiving responsibilities. Also requires that each of the parties provide job protected leave for birth or adoption of a child or in care of family members, and protect against wage discrimination. So from an overall big picture construct, that's important. Now, when one looks at the weeds of that in America or in the US, depending upon the size of employer and where you are, you know, that sort of the construct for leave is you get 12 weeks of leave under the Family Medical Leave Act. And then, of course, with COVID-19 and what we've been dealing with respect to that, we have the US CARES Act and the Family First Coronavirus Response Act, which adds additional benefits for employers and what they have to provide to employees in the States. And so from that aspect of the USMCA, it certainly does respect the sovereignty of each of the countries and recognizes that, look, these are sort of the overall things that we agree on, and you need to implement policies consistent with that. But it doesn't specifically say, okay, how much leave are you required? Another aspect of the labor aspect of the agreement is it provides that each party is to have minimum wages and also provide wage-related benefits or policies for workers, such as profit sharing, bonuses, retirement, and health care. And clearly in the US, as we all know, healthcare is a big issue. And generally it is required in one form or another with respect to employers. But in terms of the way the USMCA reads, it provides that this is required, but it doesn't specify per se what the wages are or what the nature of the benefits are. Probably the aspect of it that is probably closest to what is in the US in terms of its rules, and this sort of touches upon what Juan was talking about, is that aspect of collective bargaining. In the US, of course, we have the National Labor Relations Act, and we certainly have rules that govern concerted activity for union workers and allowing them to negotiate terms and conditions. And from that aspect, looking at the annex to the labor provision there, that's probably closest to what we have here. And so I think from this vantage point, it will, as Juan was talking about, you know, we have this rapid response labor mechanism. The idea behind it is to resolve and make sure that the parties are implementing rules that are consistent with what is in there. And I think it'll be easiest, I would say, from the parties' perspective to say whether or not there's been compliance from the CBA and the union organizing, and then the other aspects of it, the overall construct is there. And I think from the aspect of protecting workers' rights, ensuring safety and health. I mean, in the US, we have the OSHA regulations that are very long and very specific. Technically, under the USMCA, it says that there needs to be that, but it doesn't specifically say, and Mexico, for example, or Canada, needs to adopt the exact same standards that we have. But it does go very far in terms of leveling the playing field, and I think that's probably what's most important from the US perspective.
Thank you, Scott. We still have a number of questions to address, but I think we've reached the end of our time limit for the program, and we'll have to address them either via email or by phone after the program. To close, I'd like to thank everyone for joining us today. Our next webinar is next Wednesday, June 17th, and we'll be addressing the USMCA's new government procurement commitments. Our third session of the four-part series will be June 24th, which will cover trade facilitation. And our last session on July 1st, on the day the USMCA goes into effect, we'll be discussing supply chain issues. To register for these programs and to stay on top of trade issues generally, please visit the Thompson Hine International Trade Group's TrumpandTrade.com blog. Thanks again for joining us. Be well, and I hope we'll hear from you all next Wednesday. Take care.